Yes. So in the last class, we have discussed about contemporary issues in business law. So in that we discussed about Right to Information Act 2005. So what do you mean by Right to Information Act or RTI? So here any citizen of India can seek any kind of information he wants from the concerned authorities. It may be the state government authority or it may be from central government authority. So for that he has to pay certain amount of minute fee and he has to file the application online, and within 1 month he will get the required information without specifying any reason why he wants that information. Then we discussed about information. What do you mean by information? Information means it includes information in various forms like record, document, email, memos, and opinion, advices, circulars, orders, logbooks, contracts, reports, samples, press release, or data material. Other than this, the individual cannot ask for any other information. Only the information specified under the section has to be taken into consideration. Then we discussed about request for obtaining public information with whom he has to submit the request. So he can approach a central public information officer in the case if he wants any information regarding central government activities or affair, or he can approach state public information officer in case if he wants any information regarding state government's affairs. Then what are all the grounds under which the information cannot be given or your application may be rejected, that we have seen. If it is incomplete, if it is forbidden by law, then if you are asking the information which is very past in nature, like 20-year ago information, if you are asking, in such cases what happens, there is a possibility that your form gets rejected. Then there is one commission, that is Central Information Commission. So it acts as a grievance redressal committee. So if your application gets rejected, then you can file a complaint in this commission. So this commission overviews all the matter why your application gets rejected or what is the reason for not giving the information by the specified authority. Everything this commission sees. So what are the organizational structure of this commission? If you see the organizational structure, there may be one chief information officer and other 10 information commissioner. So here commissioners are specialized in various fields or various subjects like management, science, technology, corporate governance, journalism, etc. And their term is 5 years and they are not eligible for reappointment. Then we discussed about Information Technology Act 2000. So why it is formed? It is formed to give authentication to digital signature, and it promotes keeping of electronic records other than the instead of keeping manual records. So it promotes e-governance. So that is why Information Technology Act is formed in 2000. So it promotes electronic storage of data also. Then significance we discussed. What are the drawbacks of IT Act? Major drawbacks of the IT Act is it doesn't cover intellectual property right. Something which involves human efforts are not covered under IT Act 2000. Then we discussed about digital signature. What do you mean by digital signature? So instead of putting the manual signature on the document, the company now can go for digital signature. It is safe and secure. It is very difficult to forge. And one more thing, there may be some code is assigned along with the signature. So you can verify if you scan that particular code. That is about digital signature. Then we discussed about cybercrime. So what do you mean by cybercrime? Cybercrime, there are two ways. Cybercrime can happen. One is computer is used to commit a crime, or one more thing is computer is a target of that crime. So whenever computer is a target, some virus is inserted into the computer or some spam mail is sent to the computer. In that case, computer is a target. Whenever computer is used, then you can think about this one, cyber stacking, various things come, cyber terrorism. So these are the things which can be done with the help of computer. Yes, there are various types of cybercrime that we saw. Then now today we are going to discuss about intellectual property law. So what do you mean by intellectual property law, and why it is required? We have to see. So see this, intellectual property law deals with rules for securing and enforcing legal rights to inventions, designs and artistic work. So here invention means what? Invention means something new, something different, something unique, and especially invention created with the help of human effort. That means here creativity, here importance is given to the creativity of man. So that is the meaning of intellectual property right, and especially these rights are there for intangible asset, not for tangible ones. Intangible ones means we cannot see, we cannot touch, we cannot feel. For example, copyright, trademark, we cannot see, but it is there. So now the purpose of intellectual property law is to encourage new technology, artistic expression and invention while promoting economic growth. So artistic work means what? Artistic work means it may be related to some human skills are involved. Wherever some new human skills are involved, maybe it is a drawing, maybe a composition of music, maybe a literary work, maybe something regarding to the writing. So everything covers under intellectual property right. So now here creator or the inventor of the work gets exclusive rights against any use or misuse of the work without his or her prior permission. What do you mean by this? So here they are saying as the creator of the work should get some protection for his invention, or else what will happen? Others will copy the work done by someone else. So in order to avoid that, this intellectual property right came into existence. So in this, what happens? There may be a protection given for some specified duration. It may be a 10-year protection, it may be 20-year protection, or it may be lifetime, and after death, it may continue till 60-year also, depending on various situation. So that is about intellectual property. Then the intellectual work created by human brain could be in the nature of a book, an article, it may be a book. So if you are writing a book, or if you are author of any particular book, so if you see the book, there may be one sentence. Without the permission of the author, you cannot reproduce the contents which are there in that particular book, or you cannot take the photocopy of that book. For that matter, if you read the preface, there they will give you. So then similarly, art, any kind of art, song, any song, for example any film song, whether it is now newly created song, so for that newly lyrics is written, so that is also protected. Only after the permission you can use that song. Similarly, invention, if you are inventing something unique or novel in nature, then design, logo or mark used for representing the business or even a trade secret. So everything gets covered under intellectual property law. So this law came into India in the 1950s. 1950s, this law came. Then various amendments are added to the intellectual property law. Then the law got updated. So now you see, these intellectual properties are recognized by World Intellectual Property Organization (WIPO). So the rules and regulations are controlled by WIPO, that is World Intellectual Property Organization, and without the permission of this one you cannot change the rules and regulation, because it is a governing body for intellectual property right. What is the use of intellectual property right, or what is the advantage of intellectual property right? See this. First one, it provide exclusive right to the creator or inventor. Why? Because their work will be protected and it cannot be copied that easily. For copying the work, prior permission is needed, or specific term or specific duration for that the work is protected must be over. After that itself, you can copy that particular work. So that is the first one. Then you see, they encourage the individual to distribute and share information and data instead of keeping them confidential and idle. So if there is no protection is given, in that case what happens? People will keep all their invention secret, because they have one fear that their invention can be stolen by someone else, or they can take a reference from that invention and create the new invention. So these things are there. So now whenever you are taking some references or you are referring to some invention, you have to mention their name, or else it is a punishable offense. Why? Because you are taking someone else's idea. That is why you have to give the credit to that person who invented that idea first. So that is the meaning of this one. So now after this, you see there is a third point. They provide legal protection and offer the holders the attractive incentives for their intellectual work. What type of incentives they are talking about? So you may think of a royalty. Some kind of royalty is given to the publisher. Suppose you are publishing something, some incentive may be provided. So that is about the third point. Then they result in the introduction of new product to satisfy the latest taste of the customer. Why it result in introduction of new product? Because here everything is protected. So one who wants to discover something new, he has to bring his own ideas instead of copying the ideas from someone else. So that is why it promotes new inventions. Then they encourage technological advancement and making the human life simple, easier, and worth living. So in the olden days, if you see, there were no protection is given. Before 1950s, there were no protection. Anyone can use anyone's work without mentioning their name. But now what happens? Now everything is protected, and intellectual property involves a trademark, it contains trademark, it contains copyright, it contains industrial design, it contains plant variety rights. So various things are involved under intellectual property law. That is why it is governed by the separate act, Intellectual Property Act. Then they try to curb piracy by unscrupulous people. Why? Because now piracy is a main issue. For example, if you take the example of a film industry, so what happens? Immediately the date, even before the date of releasing the film, sometimes the film is very easily accessible, isn't it? Or else immediately today, if the film is released, immediately today or by tomorrow you can view the film. There are various platforms are there. So in order to avoid that, the various type of protection is given, but it is not free from drawbacks. Of course, everything has its own demerits. So you cannot stop people from committing crime. You can take some precautionary measure, or you can prevent them from committing certain crimes. So that is what this intellectual property law states. So now these are the advantages regarding the intellectual property law. There are 6 points they have given. After seeing the advantages, now we have to see what are the various types of intellectual properties are there. So now first one is a trademark. So what do you mean by trademark? So trademark is some recognizable name, some reputed name, or it may be a word, it may be a figure, it may be a sign, it may be a design, logo, symbol, or expression adapted by the manufacturer which is capable of differentiating its goods and services from those of other firm. That means, in short, you can say the trademark is something which distinguishes the firm's product from its competitor's product. So, if, for example, if you remember that the firm's trademark, then automatically it creates customer retention. Because of trademark, it creates customer retention, customer loyalty can be created. See this, for example, now Tata company, Samsung, Godrej, then Coca-Cola. In many things are there. Redmi. If you see the mobile industry now, Redmi is there, Realme is there, Moto. Then if you see bike manufacture, there are various companies, car manufacture, Maruti, Suzuki, various companies are there. That and all, they are one trademark. They created the trademark and their designs and their inventions are protected. So you cannot copy the exact same inventions or designs from that particular company. So what is a trademark of Coca-Cola? So their taste and the shape of the bottle. So that you cannot copy. Similarly, Mountain Dew. So again, for that also there is a trademark. You cannot copy. Now, registration. Whether registration is compulsory or not for trademarks, that we have to see. Registration for trademark is not compulsory under the law. When the trademark is not registered, it is called as a brand in the commercial domain. So brand means what? Brand means it is not registered under intellectual law. So various brands we know. So there is a Reebok, Puma. So various brands. These are the brands. I know that is they are registered. So but common people know them as a brand instead of a trademark. Then patent. Second thing is patent. So whether trademark and patent is same? No. What is different in this? Patent is an exclusive right granted to an inventor or the patentee in most of the country to prevent others from commercially making, using, selling, importing or distributing a patented invention without the permission from the patentee. So here trademark is a broader perspective. Trademark is a broader perspective. Usually, whenever we think about a trademark, we think about the firms, companies, multinational companies, etc. Whereas patent, it covers individuals also. So now you see what and all comes under patents. Example for patentable item. See, now there are various parts are there like computer software and hardware. Whenever you see the computer software and hardware, there are now various processors are involved. So Intel, you know, then there is a Ryzen processor is there. So various processors have their own patentable right. So now suppose Intel company want to bring in new processor, then they have to create their own ideas. They cannot take the ideas or they cannot do the exact same product and launch it into the market. That is not possible. Then drugs and medical devices, that is also a patentable item. So under medical devices, you may be knowing that H scheduled drug, because it is patented. H scheduled drug is there. Various scheduled drugs are available. Drugs means medicines are available. So it is patented and it is very unlikely to be copied by someone else. Furniture design, that is also comes under patentable, right? Jewelry, again it is a patent. How jewelry is patented? So there is a hallmark on jewelries, or else for diamonds there is a forever mark. So you may be knowing for diamond there is a forever mark. For jewelries there is a hallmark. So then there is a musical instrument that is also patentable, and fabrics. garments, everything is patentable item. So this is about the second point, patent. So now we are discussing about types of intellectual property. First one is trademark, second one is patent. Now third one, if you see, is copyright. So copyright involves basically three category of people. One is artist, one who is and one more is doing the literary work, and one more is the person who is dealing in musical instruments. So in that case, copyrights comes. So now we have to see about copyright. It refers to exclusive and assignable legal right given to the originator. Originator means the person who has created the invention, the person who develops certain original ideas for a fixed number of years to print, publish, perform, film or recording literary, artistic or musical material. For example, now filmmaking. So now let us take the example of filmmaking. Suppose one film is made in 1995, and if you are making the same copy, remaking the old film which was already released 25 years ago, in that case you want what copyrights of that particular film. So that film may be protected for 20 years. After that, anyone can copy the film, anyone can use the contents of the film, so everything is possible. So now you may be seeing the example of Coolie number one. So now the new movie is coming. So that movie came 25 years ago. Of course, now their copyright is over. The duration of copyright is over, and now it is acquired by the directors of the film, and they can reproduce the exact same film or whatever the story which is involved in that particular film. So that is about copyright. See this, under copyright law, a work is considered to be original if the author created it from independent thinking without duplication or copy. That means what? Here, work should be original in nature and you should not copy your invention from someone else. So that is the meaning of this one. And anyone with the original work of authorship automatically has the copyright to that work, preventing anyone else from using or replicating it. Suppose I have written one book. Let us take the example of textbook. I have written one textbook. So I have the copyright of my invention because I have referred various things from various sources. Then I have created one book and I have mentioned the references in the references section, what and all material I have used to prepare this particular book. So in that case, what happens? I have the copyright of this book. Without my permission, you cannot reproduce the contents of this book, or you cannot use or you cannot take the photocopy of this particular book. But the people will misuse the law, and it is possible that anyone can take the photocopy of material available. Now, examples of copyright. What are the examples can be given for copyright? Books. It covers under copyright. Articles. Articles are also involved under this one, copyright. So, what do you mean by article? Article may be in a peer-reviewed journal. So, if it is in a reviewed journal, or if it is in an international journal, or if it is in a reputed newspaper. Of course, suppose if you publish article in a reputed newspaper, Times of India, Hindu, in that case again you get the copyright. You cannot take that same article and publish it in another newspaper. So that is there. Then speeches, any speeches. If you see YouTube, there is a copyright claim. You can make a copyright claim if your content is taken and same content is reproduced by someone else. Suppose if you are doing YouTube video, then it should be original in nature. You cannot copy the video and just upload it in your YouTube channel. If you upload that, then what happens? Within 1 hour, within 1 hour automatically there will be a copyright claim and your video will be removed from your channel. So that is one more thing. Then project report, again there is a copyright. Suppose if you are doing the research work, in that case you have to prepare your own project work. If you are using the data analytics of a third party, or using the data analytics from secondary sources, in that case what happens, again you have to give the references, or else it is a punishable offense. Music lyrics, you can make the remix of the music lyrics, provided you got the prior permission from the person who has created the original lyrics. Similarly, film and website content, everything is protected. So now, after understanding what do you mean by copyright, now we have to see the characteristics of copyright. So what are the various features are involved in copyright, that we have to see now. First one, creation of a statute. So creation of statute means here copyrights rules and regulations are governed by Copyright Act. So there is separate act for copyright. See this, rules and areas of the works are given under Copyright Act. Then second one is some form of intellectual property. So copyright can be given only if it is relating to the creation of human mind. If it is not related to the creation of human mind, then you cannot ask for copyright. So that is one more feature. It should be a product of human mind. Then the monopoly right. Monopoly right means single right. Who will get the right? Only the creator of the work will get the right and no one else. Then negative right means it prevents the person from using the original work. So that is the meaning of a negative right. So it prevents others from doing the same work which is originally invented by the copyrighted person, or one who has taken the copyright. Then object of copyright. What are the object of copyright, or what are the purpose of copyright? It is done, or it is created to motivate authors, composer, artists to create original work. If copyright itself is not there, everyone will make the remake. Everyone will make the remake, and what they will do, they will not try to create something new. They will continue doing duplication of work. In order to avoid duplication of work, Copyright Act came into force. So now then there is a multiple rights. What do you mean by multiple rights? Copyright is not a single right. It consists of collection of different rights in the same work. So suppose if you take the example of now literary work, their copyright includes rights of issuing the copy. For issuance of copy, there is a copyright. Again, translation of work. Suppose if you are translating one English book to Kannada, so in that case, what happens? Again, you have to get the copyright of that particular author in order to translate that from original language to your preferred language. So that is the meaning of this one, multiple rights. So these are the features involved under copyright. So there are total creation of statute, some form of intellectual property, monopoly right, negative right, object of copyright, and multiple right. Total 6 features are there. Now, after this, we have to discuss about industrial design. What do you mean by industrial design, and how it is different from the previous 3? That is a trademark, patent, and copyright. That we have to see. So now you see, industrial design means some innovative logo, shape, size of color, etc. It refers to innovative, novel, and original creation affecting the appearance of industrial product. It could be a design, pattern, shape, size, color, etc., which is measured by the eyes of the people. That means it should be attractive in nature. By thinking of that product, you should be able to imagine that design, industrial design of the particular product. So in that case, it comes under this category. So, an industrial design increases the beauty of any product. It renders an object attractive or appealing, thus increasing its marketability, adding it to its commercial value. That means the way the company is going to present their product matters in the market. Why? If your product is not well presented, then there is no ready customers are available in the market. You know, there is no ready customers are available. You have to create your customer, then you have to retain the customer, then you have to build the customer loyalty. So for all these things, good industrial design is needed. It should be something innovative. It should be something different from your competitor. Suppose there is high competition. Suppose now let us take the mobile industry. There are various categories like now budget smartphone, mid-range, high-end smartphone, low-budget smartphone are there. But now preferred categories of the individual is a mid-ranger phone. So mid-ranger phone means from 10 to 15,000 range. Under 10 to 15,000 range, now what happens? There are high competition because there are various companies are there. Like now Redmi is there, Realme, then Moto, various things are coming. Now various designs are coming. Then quad camera setup. So you cannot reproduce the old tactics. You have to be updated with the technology, or else what happens? Competitors will take over and they will gain the market position. So that is why industrial design is needed. So now you see shape of bicycle, car, TV. So if you take the example of TV, Sony Bravia TV, what happens? Their shape, ultra UHD shape. It is something innovative. It is something different. So not done before and after they are doing, everyone is following that. So that is why industrial design also plays a very important role in creation of customer. That is the fourth one, types of intellectual property rights or law. Now, fifth one, trade secret. What do you mean by trade secret? So, trade secret means your distinctive feature or your unique selling point. What makes you different from the other? That is known as your trade secret. So, now you may be knowing like there are certain companies, food industries are there, like now KFC, they have some trade secret. They will not allow their trade secret to get openly to get open. Why? Because it is their patented right. It is their right. That is why what happens here, if you see under trade secret, it is a unique formula, practice, process, instrument, pattern, commercial method or information generally not known to others. Basically not known to others means not known to the public. Whatever you are doing is not disclosed to the public is known as trade secret, or not disclosed to the competitors or your rivals. In that case also it is known as a trade secret. So you know the Coca-Cola recipe, the original Coca-Cola recipe was known to only few people, it seems only 2 to 3 people, it seems. And original Coca-Cola color was not this one brownish color. There was some different color. If you see, you will get the information. So that is about now trade secret. Then you see, generally not known to other by a businessman can obtain an economic advantage. Why trade secret is needed? To gain economic advantage or to cross the rival's position. Suppose the rival is making the higher profit, what step to be taken by the other firm? What you have to do? Whether you have to raise the price, or whether you have to lower the price, or whether you have to keep the price as it is. So this is a competitor strategy. That also we have to see. Then it is the most valuable and confidential commercial information possessed by a businessman or industrialist, and it is known to only the people who are there in the internal management of the company, and it is not known, or the information is not available to the outsider or external people. So that is about trade secret. So now we discussed about 5 points like copyright, trademark, patent, then industrial design and trade secret. Now sixth one, if you see, geographical indication. So what do you mean by geographical indication? Geographical indication means you are identifying the product by remembering place name, or along with the product name the place name is also attached. In that case it becomes a geographical indication. What example you can give for geographical indications? Can you tell me? Product comes with their place name. Yes, tell me now. Amrita, Anusha, Ashish, Disha, Kushal, Pratish, Shifali, Vivek. Tell me, product with the place name. There are various products available in the market with a place name. Tell me. This answer. No answer. Product with place name. Just tell me. Geographical indication. Any product you can remember with the place name is there along with the product. So now let us take the example of sweet now. Sweet. So in sweet, do you remember any sweet along with the place name?
Dharwad Peda.
Ah, Mysore Pak, Dharwad Peda. Yes, so see this. This is a geographical indication. Although it is produced here in Mangalore, so it doesn't matter. But the geographical indication is there. Similarly, soap industry, if you see, there is also the geographical indication is there, isn't it? Mysore sandal soap. So again, and silk. If you see, there are various geographical indication for silk, Banaras silk. Then for saris, there are various geographical indication, isn't it? So these are the things comes under this category. See this, where the product is identified by a particular geographical area, it is known as geographical indications. It is a sign used on the product that have specific geographical origin and possesses qualities or reputation of that origin. So example, basmati rice, see this, Banaras silk, Mysore sandal soap. So these are the example of geographical origin or geographical indication. This is about sixth one. Now seventh one, plant variety right. So what do you mean by plant variety right? So it is a right given to basically for agriculture, or it is also known as a plant breeders right. So one to take care of the plant, for them certain rights are given. So what types of rights are given? Maybe to receive the royalty from agricultural land, or maybe for this one seeding and cutting the flowers. So various things are there. So that and all comes under this plant variety right. See this, it is also known as breeder right or intellectual property right granted to the breeder of new variety of plant. Plant variety rights are intended to promote innovation in producing plant varieties for the development of agriculture, floriculture. So floriculture means the flower business, etc. So these are the things covered under this category. So total seven types are there. Seven types of intellectual property right. I hope you understand.